Hello, California. My name is Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, and I want to congratulate you on reaching the national finals. It's quite an honor, and I look forward to hearing your presentation.
You're muted.
All right. I am Edward Volpe. I'm an attorney in Denver, Colorado. I've been working with this program for a long time, and I congratulate you on the success of your hard work in 2 semesters. I think we are moving toward a position where people who have civic education such as you are going to be an important element of our society. I thank you for doing this, and I thank your teacher for working with you. I look forward to your presentation.
Hi students, my name is Caitlin Johnston. I am an attorney in New York City, and when I was in high school in Indiana, I was a We the People participant. So I know what it's like to be in your shoes, but I never made it to nationals. So congratulations on being here. It's an amazing achievement. I very much look forward to the discussion. And I'm a little sore off hip surgery, so if it's all the same to you, I'm going to stand for your presentation, but please ignore me, and best of luck.
Thank you. Good afternoon. We are Foothill High School's Unit 5, representing the state of California. My name is Barrett Fahey.
My name is Justin Choi.
My name is Rohan Abraham.
My name is Mary Thurlow, and we'd like to thank the judges, the audience, and timekeeper for being here today. And we'd like to introduce our coaches, Mr. McBride, Mr. Dedamore, and Mr. Tellos.
All right, thank you. As you said, this is Unit 5. We're going to go with question 1. So I'm going to read the question, and then once I'm finished reading the question, then we will start the time for the 4-minute presentation. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the United States Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? You may begin.
In Wisconsin v. Yoder, 1971, the court found that the Amish were justified in limiting their children's education as it was unnecessary to their religious life, especially for an endangered religion. The case has been controversial in its reception, and our unit reflects this split. Justin and I feel that this decision correctly interprets education as a positive right that people may refuse if they believe it to be non-beneficial or a violation of their negative rights.
However, Mary and I disagree with this decision and agree with Justice Douglas's dissent that the majority opinion prioritizes the rights of the parent over the rights of the child, when the education of the child is a matter on which the child will often have decided views. In truth, the Free Exercise Clause guarantees that the government may not infringe on an individual's practice of their beliefs. It does not state that individuals may force their beliefs onto another person, even their child.
Rohan and I, on the other hand, agree with the court, as it decided Yoder as a compromise between religion and the state, with the understanding that both the parents and the students themselves value their formal education less than their religious beliefs. Should a child want to break from family tradition, the laws and the courts give them ample opportunity to do so after they turn 18. The Constitution guarantees that the government may not infringe on people's religious practices, and it does not explicitly guarantee a right to education for minors.
Although Yoder determined that there are no direct mentions of the right to education in the U.S. Constitution, this is partly due to the fact that there was no such thing as public education during its writing. Instead, education was conducted primarily through the church. Scholar Charles Fahey noted that, by this logic, the First Amendment protected the people's right to education, at least a religious one. As more states adopted secular public education requirements, education lost its protection through the First Amendment.
The Supreme Court further denied any federal right to education in San Antonio Independent School District v. Rodriguez, 1973, viewing it as a purely state-level right. Every state constitution has a reference to a right to an equal and fair education, but the qualities of these educations differ, especially within lower-income school districts, demonstrating that a right to education is not enough. Instead, it must be coupled with corresponding legislation to ensure its protection.
Our home state of California reflects this necessary balance. Article 9, Section 1 of the California Constitution identifies a responsibility for a statewide education system open to all. With the power of the Education Code behind it, a series of bills updated each legislative session, the right to education in California acts as more than just a symbol, but rather as an essential protection for all Californians by setting standards and funding for diverse courses.
When religion comes into conflict with statutory rights, such as access to contraceptives or civil rights laws, the question arises which will take precedence. Recent courts have sided with religion over other rights using a combination of the Free Exercise Clause and an aggressive interpretation of the Religious Freedom Restoration Act, which has allowed religion to develop into a tool for depriving citizens of other crucial rights.
Although Justice Scalia's majority opinion in Employment Division v. Smith, 1990, states that religion cannot excuse an individual from a generally applicable law, this standard is now hanging by a thread. Scholar Lee Epstein noted that the Roberts Court decided for religion in 82% of cases and only 18% against, a huge shift from previous courts. Recently, the court wrote in Tandon v. Newsom, 2021, that government regulations trigger strict scrutiny whenever they treat any comparable secular activity more favorably than religious exercise, a step back from Smith and towards religious rights.
In a 2020 article, scholar Howard Gilman wrote of the weaponization of the Free Exercise Clause, noting that many groups use this clause as a tool to discriminate against the rights of other individuals. The court must protect the principles of the Free Exercise Clause in the practice of an individual's religion, but not at the expense of other essential rights. Thank you.
Well, thank you. I'd ask that you put any notes you may have aside when we ask you the questions. So, how should we analyze laws that have an impact on religious beliefs?
I would believe that we should lay more emphasis on the standard that was established in Employment Division v. Smith 1990. And I think it is a more fair application of laws that may require religious exemptions. And so I think that the standard is more fair.
However, one thing to note is Justice Blackmun's dissent, where he noted that in the case of Employment Division, it was related to the Native Americans' use of peyote in religious activities. And while Employment Division does do a good job of a broad, sweeping generalization of all religions, its applications towards minority religions can harm those religions themselves.
You pointed out that the California Constitution, as nearly every other state constitution, provides for funding of education. May that public funding be used to support private and religious schools as well as public schools?
In the case Espinoza v. Montana, it was found that private funding or funding from the state could be used to deliver private vouchers to parents wishing to send their schools to send their kids to public schools or religious schools. And so while I don't think that the state should directly fund these schools, I don't see a problem with providing vouchers for parents wishing to send their kids to these schools.
I do agree with my unimate on the point that if we are to treat all education systems, private and public, secular and religious, there has to be some sort of equality between these school systems. So then in the case of funding towards private education and religious education systems, as long as the government is willing to provide equal, fair, and just funding that is meant to not directly support the religion themselves, but to directly benefit the common good of the education system themselves, then I think that that type of funding is justified.
So for the half of the panel that believes that the parents ought to be in control under Yoder, I think someone mentioned that if a child wants to break with the parent's religion, they can wait till they're 18 and do so. Would your analysis be different or the same if we are talking about a ultra religious sect that believes in marrying off their young girls before the age of 18 and kind of compelling them into marriages and childbearing. How do you tease out the rights of the child and the religious rights of the parent in a case like that?
Well, I believe that in such a case, the government would be able to step in under child abuse laws possibly and protect the child from any harm at the hands of the parents. However, cases such as Troxel v. Granville 2000 have created a strange situation in which parents, I do believe, have excessive control of their certain aspects of their child's life. However, I believe that the standard strictly set by Wisconsin v. Yoder, and specifically in the case of the Amish, was a fair standard to say that the children in that case specifically can break at the age of 18 from their parents' belief systems, and that and remedy any harm that they may believe has been done to their life through their parents' religious beliefs. But in abuse cases, I am worried to a degree by the standards set by the court in terms of the extensive control that parents have over their child's lives.
So because the child can make up for lost time once they turn 18 and obtain an education, that's why you're saying that there's a distinction? Just want to make sure I understand.
Well, yes, I believe that the Wisconsin v. Yoder standard, because after the age of 18, a member of the Amish community may leave and they may find their own life and separate themselves from the religious community and seek out education that they may have missed. I believe that it was a fair standard to apply in that specific case regarding the Amish community.
And if the children in that case, they didn't, but if the children in that case said, I want to go to school, I want to go to high school, I don't want to be done at 8th grade, do you think the court ought to have come out differently, or your position holds? And this is for anyone.
Yes, I think that is the argument that my unit mate Barrett and I make, is that the court really doesn't take the child's opinion enough into hand, and it really places the religious rights of the parent over the child. And so I think that the court should consider the child's opinion more in these situations such as education.
I think especially within school systems themselves, children and minors often do have rights themselves that they don't have when they're in their parents' control, with cases such as Tinker v. Des Moines, 1968. Students do have the ability of freedom of speech. They have the ability to control their own speech and actions. Whereas when they get back to the home system, they start to fall under the parents' control once again. And so education is more than just learning. It is also an environment where students are free to develop themselves, and that just cannot be accomplished as effectively under parental control.
Should public school students be allowed to participate in religious clubs held on school grounds after school? Why or why not?
I would say that there is no problem in a student practicing in or being in part of a religious club after school hours, because at that time the school is not really associated with that club. It just becomes an area where the club can gather, as long as the club at hand is not discriminating who can join their club, as defined by the case where a private school can allow whoever they want into that club. And so, yes, as long as they're not violating that.
There have been a number, there have been a number of Supreme Court cases concerning religious exercise on school campuses, such as Santa Fe Independent School District v. Rodriguez. But I do believe that the most applicable standard here, and the one that we should return to regarding these situations, is the majority decision in Tinker v. Des Moines 1969, where it was noted that students do not leave their freedom of expression behind at the schoolhouse gate. And that freedom of expression involves the right to association and the right to form a religious club such as this in this case, the hypothetical was after school hours, but I believe that during school hours as well, such clubs should be allowed to operate.
Thank you very much. Relax. You finished not only this presentation, but I think we're done for the day. So well done. I was really impressed with each of your ability and desire to express your opinions and thoughts, not just to cite what Supreme Court justices have said or what court opinions hold, but what your own personal beliefs are, and that there's disagreement amongst the group. And that's fine. You each were able to express what your own thoughts and opinions were, and that was great, in conjunction with providing us with a lot of case precedent and giving us a lot of information. So it was very well done. I want to commend you for that. I want to encourage you to continue this education and this process because it's very important, very critical. You know more than most people in this country about the Constitution and civics. Continue to nourish that, continue to educate others, and thank you for your presentation today.
Thank you.
I agree with that comment. With your knowledge, I hope that you will become active politically and civically and use your knowledge for the benefit of your fellow citizens. I think that is very, very important. I enjoyed your presentation. You had a wealth of cases that address the same issues. I was very happy that you know about the April 19th decision on Tandon v. Newsom, which said you can't regulate the gatherings of religious groups to 3 families in one house if you're going to open hair salons and bars and the like. And so the fact that you're on top of strangely enough, a California case is wonderful news. A good reference to Tinker versus Des Moines. With regard to my question of whether or not tax dollars can be used to support private schools and or religious schools, you should be aware of the child benefit principle that the court has applied, and that is you can fund schools regardless of their orientation, public, private, or religious, if you're supplying books, you're supplying, computer pads and that kind of thing. As long as it benefits the child, it doesn't matter where the child takes up those benefits that the state is conferring. And again, that applies to a voucher system. A school district can have a voucher system which says a certain amount of money goes to the student. He can take it to whatever school he or she wants. And that's been applied rather consistently in recent times in any event. The reference to the Grenzel case I thought was excellent. The Espinoza case versus Montana, I thought that was great. That's the voucher system. And the San Antonio Independent School District versus Rodriguez. It was interesting that the Supreme Court held that the regulation did not violate the US Constitution, but it did in fact violate the California Constitution. And California then prohibited the practice, but it would have been allowed by the Supreme Court. But again, a great understanding. Your responses to the questions were excellent. And your knowledge, as you demonstrated in this, 12-minute procedure, was very, very impressive. Thank you for your hard work, and thank you to your hardworking teacher.
I'll just echo all those comments. Not what Judge Volpe said, because he's the constitutional scholar that is going to really test whether you got all of that right. I was really looking for defending your arguments, but bringing in new perspectives, especially in the follow-up. That's what distinguishes the good teams from the great teams. I think you did an excellent job. Rohan, you defended your position, but also you were able to kind of distinguish and work your way around the hypothetical. that I presented to you. It's interesting, if you read the Amish Heritage Foundation blog, you'll see that the woman who started that actually alleges that the religious objection is kind of a ruse for child abuse, because the Amish actually don't want their children going to school past 8th grade, because they want them in the cornfields and doing the manual labor. These issues are difficult, and there are tricky angles to any of these policies, especially when it comes to religion. I mean, it's all over the law, but especially with religious beliefs, like nobody has figured out what the right answer is here. There's no clear statement of what's right. So being able to kind of tango with these different viewpoints and go back to the case law that you've studied and show us what you know and show us how you reason. Barrett, I thought you did a great job just going into the tinker stuff and actually articulated quite a very eloquent point there about students have freedom of speech at school, but the minute they go home, they don't. And I just thought you did a very good job bringing compelling arguments. You worked really well together as a team as well. So thank you.
Thank you.
Okay, well, that concludes the hearing today. We're going to give you guys all a big round of applause for a job very well done.